Comprehensive equal employment laws provide a broad-based protection for applicants and employees. Anti-discrimination law refers to laws on the rights of people to be treated equally. Although the very first Civil Rights Act was passed in 1866, it was not until the passage of the Civil Rights Act of 1964 that the keystone of anti-discrimination employment legislation was put into place. Title VII, the employment section of the Civil Rights Act of 1964, details the legal protections provided to applicants and employees and defines prohibited employment practices. Title VII is the foundation on which all other workplace non-discrimination legislation is built. Title VII of the Civil Rights Act states that it's illegal for organizations to discriminate in any way based on a person's sex, race, national origin, color, or religion. Coverage includes hiring decisions, terminations, promotions, demotions, compensation, working conditions, and many other personnel actions. Title VII, as amended by the Equal Employment Opportunity Act of 1972, covers most employers in the United States. Any organization meeting one of the following criteria must comply with the rules and regulations that specific government agencies have established to enforce the Act. All private employers of 15 or more employees, all educational institutions, public and private, state and local governments, public and private employment agencies, labor unions with 15 or more members, and joint labor management committees for apprenticeships and training. Title VII has been the basis for several extensions of EEO law. For example, in 1980, the EEOC interpreted the law to include sexual harassment. In response to several U.S. Supreme Court decisions during the 1980s, Congress amended the Civil Rights Act of 1994 to strengthen legal protection for employees, provide the basis for jury trials, and allow for damages payable to successful plaintiffs in employment discrimination cases. Several important executive orders have been issued by the U.S. President that affect the employment practices of federal contractors and subcontractors. The OFCCP in the U.S. Department of Labor is responsible for overseeing federal contract operators and ensuring that unlawful discrimination does not occur. Executive Orders 11246, 11375, and 11478 require federal contractors to take affirmative action to compensate for historical discrimination against women, minorities, and individuals with disabilities. Federal contractors are required to develop and maintain a written affirmative action program, AAP, that outlines proactive steps the organization will take to attract and hire members of underrepresented groups. This data-driven program includes analysis of the composition of the company's current workforce with a comparison to the availability of workers in the labor market. The overall objective of the AAP is to have the company's workforce demographics reflect as closely as possible the demographics in the labor market for the workers who are recruited. The contents of an affirmative action program and the policies flowing from it must be available for review by managers and supervisors within the organization. In addition to extensive workforce analysis, the AAP includes goals, timetables, and documentation of good faith efforts to reduce and prevent employment discrimination against historically disadvantaged groups. Organizations implement outreach programs, targeted recruiting, and training programs to recruit and advance women, minorities, and people with disabilities. The original purpose of the Civil Rights Act of 1964 was to address race discrimination in the United States. This concern continues to be important today. To take appropriate actions, employers should be aware of potential HR issues that are based on race, national origin, and citizenship.